Good evening. Welcome to the Zoning Board, Woodbury Zoning Board of Appeals. Please rise for the pledge to the flag and a moment of silence for those who perished in 9/11 and those who are suffering in its aftermath. Thank you. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. This is the Woodbury Zoning Board of Appeals. We meet the second Wednesday of every month. Our next meeting will be on October 9th, and it will be at 7:30. This one was postponed by a half hour due to the 9/11 ceremony. Your board members, to your far right, we have Mr. Joseph DiVenuto, Mr. Gary Kestenbaum, Mr. Kevin Abrams, Mr. Craig Brady, our recording secretary, Ms. Jessica McLennan, our counsel, Mr. Robert Dickover, and I'm Karen Ungerer. We do have an executive session. We're going to meet for a few minutes, so if you would be patient.
meeting for adjournment.
Hello? Okay, it's on. Thank you for your patience. Next on the agenda, has everyone read the minutes from August 14th?
Yes.
Do I have a motion to accept the minutes as written?
I make a motion.
Second?
I second.
Any discussion? All in favor?
Aye.
All righty. New business, we have none. Action on decisions. Schwimmer is the first one. Review decision for an area variance to permit the installation of an 8-foot-high solid pool curtain around an existing in-ground swimming pool. Said property is located at 21 Vanderbilt Drive, Highland Mills, 25102. After several pages of facts and findings, the decision is as follows. In employing the balancing tests set forth in Village Law, Section 7-712B, letter C, and taking into consideration the board's findings as set forth herein, the board hereby determines to deny the variances as requested. Joe, how do you vote?
I vote aye.
Gary?
Aye.
Kevin?
Aye.
Craig?
Aye.
And I vote aye, so the variance is denied. Second decision is Cruz, review decision for a special permit to permit the continued use of a second dwelling unit for an individual family member's mother-daughter pursuant to Section 310-35 of the Village Code. Said property is located at 39 Pleasant Drive, Highland Mills, 211-153. Once again, after several, this is a special permit. This is after several pages of facts and findings. Resolution of approval. Now, therefore, the Zoning Board of Appeals resolved to issue the special permit as said proposal is depicted on the plans identified above and upon the conditions outlined below, and the chairwoman or her designee is authorized to sign the plans upon satisfaction of those conditions below noted to be conditions precedent to such signing. Specific conditions. Number 1, this approval is for one additional dwelling unit to be occupied by the mother of the applicant, Kimberly Cruz, only, being a person directly related to the owners of the principal dwelling unit, that is the parent of Kimberly Cruz and owner of the property, as described within the application packet. This approval hereby incorporates this description by reference, and this description of use and occupancy shall serve as the outer limit of the activities that can be carried out without amended approval being granted. Number 2, in the event the property is either sold or the additional unit is vacated, this special permit will become null and void. The property shall then be restored to its original single-family status, and permanent cooking facilities, for example the stove, shall be removed. Number 3, all facilities are subject to an annual inspection by the building department, and the owner shall make the premises available for that inspection upon due notice from the building department. Failure to make available shall render this permit null and void. Number 4, this special permit approval does not authorize any construction. No indoor or outdoor amenities or accessory structures or outdoor fixtures, including but not limited to walls, mechanical units, etc., may be constructed, placed, or erected without approval of the building inspector or the Zoning Board of Appeals, as the case may be. Number 5, the homeowner and the intended occupant shall sign the special permit upon its approval by the Zoning Board of Appeals. And there are no general conditions. Joe, how do you vote?
I vote no.
Gary, how do you vote?
No.
Kevin?
Aye.
Craig?
Aye.
And I vote aye. So it's a 3-2 split vote. Public hearings, the Shops of Woodbury has requested a postponement until October. Do I have a motion to extend this public hearing till the next month? Second?
I'll second it.
All in favor?
Aye.
All right, so next month, Shops of Woodbury will be on the agenda once again. I'm going to switch the applications here. We're going to do Sofer. Is Mr. Sofer or Mrs. Sofer here? I'm going to do the Sofer application first, and then I'll do the Reineke Veit application. SOFR is a public hearing for an amendment to an existing variance granted on September 12, 2018, to permit a tan insert to a 6-foot-high solid stockade fence, whereas said variance was granted to permit only white vinyl fencing. Variance is required pursuant to Section 146-7D, whereas proposed fence will be multicolored. Said property is located in the R2A zoning district at 14 Pheasant Run in Highland Mills and is known on the Village of Woodbury tax maps as Section 247, Block 2, Lot 5. And Mr. Sofer, would you approach the podium, please? I can't think of the word. So in 2018, you were granted a variance for a 6-foot white vinyl fence in the front and side yards of the property, correct?
Yes.
And then when you went to purchase materials, you thought that the tan would look nicer, it would match the house, and so you went to the building department, spoke with Mr. Thomas Berger and asked him if it was okay if you put tan inserts in the fence, and he agreed. He then issued a building permit for the white fence with tan inserts.
Yes.
You put up the fence, and 2 months later, someone complained, and so you were issued a violation notice, correct? And had a court appearance at that time. That's when you returned to us to see what we could do. Is there anything you'd like to add to what I've said?
That's basically that's what I want to say, that the building inspector gave us the permission, and he thought that if a building inspector...
Is your microphone on? Can you hear him, Jess? No, could you turn it on? Or it is on? Oh, it is? Okay. You're soft-spoken.
That building inspector need to be trustworthy. If he said something, so today he said one thing, tomorrow another thing, how we can trust him what to do? And we will never go into this to order this 10 fence and to install it if we know there is anything that could be a problem with this fence. We're never going to, we're not looking for any trouble. We're not good to do anything against the law. We're not, that's it.
So basically...
It's really one more thing, that there's several people in the neighborhood that also choose to make this fence. And it's really more expensive fence. It's, we did it to try to enhance the property, the neighborhood. It's more expensive, actually. And you can see also our front fence facing to the road. We did not a 6-foot solid fence. We did it like 5 foot and then 1 foot.
With the lattice on top, yes.
So we tried to make it very nice, and it should be, for the nicer for the whole neighborhood.
Does the board have any questions for Mr. Sofer? Or comments?
question.
Yeah, go ahead.
I got a question for you.
For me?
Yeah, for you. I just want to clarify this. Mr. Sofer got a variance.
Yes, he
It
did.
was voted on, it was approved.
Yes,
The variance was for a white appurtenance fence.
a white vinyl fence, yes.
And an unintentional mistake was made by the building department. Unintentional mistake. Mr.
Right, it was
Sofer,
basically
at some point,
right, he-
decided, I would prefer a tan.
Right, with
For whatever
the,
the reason. I
right.
would prefer a tan. And then the building department issued a
right, it said there'd be no problem and gave him a building permit.
accidentally.
Correct.
mistake. And so this represents an amended application by Mr. Sofer for a tan?
Is this a-
Just trying to understand what this is.
We're going to amend the, to allow for the tan fence.
Well, what's the process that allows, I'm just trying to understand the procedure.
This matter is before you this evening on a rehearing. This board, approximately 1 month ago, determined by unanimous vote of its members to rehear the matter. And what you're hearing is for a modification of the previous variance issued to alter the white vinyl, the white color to tan.
And theoretically, the unanimous decision concluding that something had substantially changed that would allow him to come back for a variance on a variance
Right.
was that the building inspector had made the mistake? Is that, I'm just trying to re-understand.
He went to court.
No, it didn't.
No, well,
There's an appearance ticket.
he had an appearance ticket for court, came before us, and in order for us to rehear, we had to have a unanimous decision to decide whether to listen as we are this evening, and when we vote, whatever, when we take our vote, whatever we decide has to be unanimous.
Any of us recall what the purpose, what the thinking was behind the unanimous decision? Did we conclude
No,
that Mr. Sofer had been misled accidentally, or, because normally, we've been voting in many cases that changes in situation aren't substantial enough to rehear cases. We've done that a number of times recently. I'm just trying to level set myself on what basis we are even considering the change in color.
Because it's against the code.
No, it's against the variance.
The variance, I mean.
What I'm saying is, what allows them to come back and say, you know what, I don't want white, I want tan? What stops an applicant from coming back a month later and say, you know what, I don't want tan, I want green? That's what I'm
No,
trying
but
to...
here's
But there's no
the issue
color
was,
in the law.
yeah, well, it's multicolored now because it's two
This
colors.
is not the issue of color.
The-
It's
the issue is
of
that Gary
color.
issued-
Rehearing, when someone decides, I don't like what we did the month before.
Okay.
Rehearings.
He did not go to the store and say, I'm going to put up a tan fence, put it up, and even though the building permit said white. He came back to the building department, asked them, listen, I'd like to put up tan, it matches the house, can I do that? The building department said, sure, here's your building permit for a tan insert fence. He put up the fence with the tan insert. And
Was issued a
somebody,
violation.
right, because someone complained.
So we issue a violation.
I'm just fuzzy on the basis by which the board said, yeah, come on back, we'll reconsider the color change. But I'll let it go. I'm still a bit confused, but I'll let it go.
Kevin, did you want to say something?
Oh, no,
Oh,
I'm ready
all
to
right.
go.
Anyone else on the board have any comments on this before I open up to the public?
Open away.
Okay. Before I open it to the public, we do have a letter from a neighbor, Mr. Cliff Ader, who is not in favor of the fence because he felt it was should have been a solid white fence, and he said that the applicant chose not to comply with it, and therefore he shouldn't get the tan fence, among other things. So I'd like to enter that into the record, that letter. So is there anyone in the first row who wishes to speak to this application? Second row? Third row? Last row? Okay, do I have a motion?
I make a motion, we close the
I want to.
public hearing.
Okay, wait a minute. Did you need to say anything else, Mr. Sofer, before I close the public hearing? Okay, all right, I just want to, all right, so,
I made a motion to close the public hearing.
okay.
I second it.
All in favor?
Aye.
All right, so at the end of the evening, we will render a decision, okay? You're welcome to stay, or you can call the building department in the morning, okay? Okay, we have now public hearing, Reinecke Veit, continuation of public hearing for an area variance to permit the construction of a single-family dwelling on a pre-existing lot having no frontage on a public roadway or suitable roadway approved to the satisfaction of the highway superintendent. Said property is located between 97 and 101 Smith Clove Road in the R2A zoning district and is known on the Village of Woodbury tax maps as Section 218, Block 2, Lot 88. And I see the applicant's representative is here. Could you give your name for the record, please?
Justin Gimple from Levinson, Reinecke & Gimple here on behalf of Ms. Lynn Veit.
All righty. We did receive a memo from you, but we got it yesterday. And we need to look at some of the things in here. We really didn't have the time. But why don't you state your case? This is a landlocked piece of property.
Right, and essentially what the memo goes over is the fact that there is a area variance exception included in Section 7736, which would allow the board to grant an area variance pursuant to the criteria of Section 7712. And it specifically creates that opportunity when there is a landlocked piece, and the case law that surrounds that allows for that property that does not have frontage on a public road to be accessed through easements, right-of-ways, and it specifies in the case law that there actually is not a specific way that the property needs to be accessed, or the building built on the property needs to be accessed, but that access just needs to be sufficient for the emergency vehicle. We've set forth the fact that that is the case, and we've requested comments from the emergency vehicle, or the police, the fire department, and the ambulance corps, and all have said that the proposal would be sufficient for their needs. So as far as the case law under section 736, subsection 3, it meets those requirements. The other aspects that the board would have to make a decision about an area variance are addressed in the application about whether or not this has an impact on the community.
Right, 5 prongs, right.
Right, and all of those issues really are not, in this case, a problem. This is not going to have any change to the community, to the residential community with homes similar to the size. In fact, its lot is bigger than many of the lots of property in its surrounding area. There are actually going to be substantial woodland in between them and other properties. The only addition that this is really going to have as far as the impact on the community is an extra car or two coming from a residential home. And so that's our position for the board.
Anyone from the board have any comments, questions, concerns they'd like to address? Joe?
This is a triangular shaped piece of property. I'm still relatively new at this, so you have plenty of frontage on the front, and you seemingly you have 51 feet side setback on one side and 32 on the other. It's the back part. There's no numbers here that say the setback for the back. Now, theoretically, it's more than 50 feet. Am I correct in that?
The building, if you look at that, there is a hash-marked triangle.
Yes.
That's essentially where all of the setbacks converge. Building within that triangle would meet the building requirements. This building only takes up a small portion of that. Well, it takes up a substantial portion of that triangle, but it meets within all the setbacks that are required by the town. That's
So
why
you
the
would
building-
have the 50 feet that you would
Right.
need and then
That's
some.
why the building department, the building inspector did not require us to ask for an additional or variance, sorry.
All right.
So every other aspect of the requirements to have a building permit for this property are met. The only aspect that are not met is it having the road frontage, but then there is the exception for the variance that the ZBA can grant.
I have a question on the ownership. When Mr. and Mrs. Veit were married, did they own all of this property together? And then during the, did the divorce create her owning this piece, him owning that, or how did that work?
So that property had been subdivided back, we believe, in the 40s or 50s, and created these separate parcels.
Okay.
So each one of them had been created as a separate parcel. The Veits did own all 3 parcels. but
Together?
As separate parcels. They were never joined.
No. I mean, did they joint ownership of each of the parcels?
The thing is that she had come to own them at an earlier time prior to the separation.
She had 2 lots and I had that house.
Yeah.
I figured out
And
Okay.
if you look at the attachment that I have to the memorandum, it shows that in 2005, she had acquired them from Burns Albert.
All right, I
Both
saw
these 2
that.
lots.
Yes.
So which two?
The ones that, the one that the proposed building is
So
on,
85.231 and 89.
and 89, correct.
So she,
Oh, no, not 85, 88 and 89.
88.
she had contiguous ownership at one time.
She's had continuous ownership since 2005 in her own name. And she bought those directly from the prior owner in her name.
Madam Chairman?
So- yes,
Just
go ahead.
follow up on this. I'm not clear on this at all.
Yeah, either am I.
My inquiry is, did the applicant ever prior in time own 85.231?
No. She owned 88 and 89. Mr. Veit owned 85.
And she was never an owner with him in 85.231?
That's my understanding.
That was on the deed, that's how we
And this
could
is
you
Mr. Veit.
Perhaps we'll hear from him.
Well, if you would like to have Mr. Veit come up, we can have him come up and he can put on the record that he has been the sole owner of that property.
So would you please, Mr. Veit, approach the podium? Thank you.
You own, right. You own the house, which is on this one, 85.23. You can just.
I'm the sole owner of 85.231. Lynn's the sole owner of these lots.
Okay.
That's currently, but in the past, did Mrs. Veit ever own with you 85.231?
No,
Did she ever own it in her own name?
no.
Okay.
And that's confirmed here.
Right, so that on the, we got that.
Madam Chairman, one more question?
No, go ahead.
Or maybe more than one. Counselor, I think it's been stated that this lot was created by the takings of the New York State Thruway.
That's, the circumstances of the lot were created that way. It's hard to go back based off the chain of title that we have to determine exactly when the lots were subdivided. They were pre the creation of the thruway. So some of the property that was subdivided was taken when the thruway went in, creating some of the circumstances that we're dealing with today.
Do you have that subdivision map?
We don't have that subdivision map, and that's one of the things that's been difficult to find. We just don't know what happened.
Have you looked for the appropriations map in the takings?
I believe Mr. Reineke's looked for that, but I don't have, my understanding from my discussions with him is that we've had title searches done, and we've been unable to find a clear path at the creation on its onset pre the thruway. So the earliest verification we have of the properties in there are from the date of the thruway going in and out.
Find it unusual that you can't find the appropriation map. Right? Was there a fire?
I don't know. I'm not sure.
But isn't a real thing that we're trying to get is that Lynn owns the 50-foot right-of-way going in. And then she owns the piece in the back. And now Randy wants to grant an easement over his property to have access to the back lot.
Correct.
That's what you're really looking to do.
That's it. In a nutshell, that is what we're asking to do. We're extending an existing driveway into the back lot.
What prohibits Mr. Veit from granting fee title to the space that would be the right-of-way to Ms. Veit?
There has been some looking into that, and it's been a difficulty with the having the engineers and the surveyors in creating that space. That has been something that has been explored, but this is an avenue that is a legitimate possibility for him to utilize. And there's no benefit or real change that would have a substantive impact upon the circumstances. The easement, by creating an easement, would grant that person, whoever owns that property, the right of way to go through and utilize this driveway. If you created the fee, then you'd have to create an easement for Mr. Veit to utilize the section that he would have to use. Either way, there would have to be an easement involved in this.
Well, he's already using this, isn't he?
There would be about, it's hard to see, but on the map, would be a section, if you were to grant an easement, there is a section on Mr. White's property that would be utilized by both driveways.
Well, the driveway on Smith Clove Road, the one that says bituminous driveway, and Mrs. Veit owns that section, correct?
Correct.
Where it says gravel driveway,
That's she's owns,
she owns that also.
until it gets to Mr. Veit's property.
Okay, so she owns all of this, all of those, that from there to there.
And there's
Right,
about a
right.
30-foot section of driveway
Right.
that's existing that would go into the easement that's proposed.
Well, does he have an easement again, through her driveway?
He does.
Okay,
So if he gave her the 50 feet or whatever she needed, then he would need an easement.
Then he would need an easement.
To
The other
get
way
to
would
you're
be
right,
property,
right, yeah,
Because there's a section that he would have to drive over that she would be at.
right.
Does that make sense?
Not to my thinking.
Well, no, but,
He's not gonna have an easement on his own property.
Yeah.
Well, but that's the point, is
Yeah.
if you were to grant that to her in fee, so she was the owner of that property,
Well, there is
there was a section then that she would have to re-grant an access to him.
There is a
Right.
difference in those circumstances. The difference in the circumstances would be that if the ownership was changed so that it was her ownership, then she would have the right to get a building permit to build on that property.
Wouldn't need an
She wouldn't need any, she
She
wouldn't.
wouldn't
She would
necessarily
still
need a variance, but he
variance.
would still
No,
have to
no,
have
she
it.
wouldn't need a variance.
Yeah,
would
because
not
she
need a
doesn't have
variance.
any
No.
road frontage.
She would not need a variance.
She would not.
Oh, she would not need a variance?
She would not need a
She would have fee access to the
Right,
public street.
exactly. So that gives her the right to get a building permit, and then Mr. Veit already has a residence, if you will, that's already built.
Right,
He
but-
doesn't need, he doesn't need any building permits.
But as far as a actual effect upon the people who live on that road and that access,
No difference.
there's no difference.
No, but from a standpoint of protocol,
Well, except
Go-
for from a
going in the other
but there's
direction
a
gives her the
specific
right-
allowance in the law to allow for the area variance instead of creating a situation to transfer these properties. And Mr. Veit would also have to agree to do that, which he's obligated at this point to grant the easement. He's not obligated in any way to transfer property to her.
And that's based on what?
That's based off of their divorce.
Are those papers
That's a
available?
contractual obligation of his.
Have we seen that?
no,
We
I
have
haven't
not
seen
seen
them,
that.
no. Should we be seeing those,
I
that
think
portion
we
of
should
it?
Take council's representation that it's within their
Yeah,
Okay.
if you wanna
stipulation
Okay.
of settlement reduced to judgment, if council's ready
And
to
it will
make
be
that.
both, it's both a legal obligation as far as an order, where if he did not follow that, he could be found in contempt, but it would also be a contractual obligation of his.
Right. Okay.
Whereas he does not have that obligation to grant her any property, to transfer title, or to give her fee. So that is one hurdle that would have to be overcome. One's definite, one's not.
Did you turn that on to say something?
I turned it off.
Oh. I personally need some more time. I need to digest some of this and look at some of the previous decisions the board has made. Probably some more advice from council.
Just so you and I understand each other, I've read your memorandum, I've looked at the cases that you refer to in there, they were not new to me. We don't share the same legal conclusion with respect to this matter. And one of the concerns that the board has, as do I, is what is the precedent, if any, that may or may not have been established in the village on prior applications of this nature. We would invite you to make inquiry of the building department as to what prior decisions they may have on record with respect to 280A applications when the community was a town, as well as applications under 7-736 of the village law since the community became a village, so that we could examine those, and you could as well, to determine whether or not the village has in fact waived the formal status requirement of 7-736. 776.
We did not obtain specific instances, however, we did talk to the building inspector, who assured us that this had been not a unique circumstance or a unique practice in the past, but if the board would prefer us to have specific cases that we can point to developed by the building inspector, we'll do so.
I think that
I would,
be very
yeah, I would
helpful
like,
to
it
the
would be
board.
very helpful, yes.
Certainly we'll do that then. Is there anything else this evening?
I don't have anything. Anybody, anyone else on the board? Is there anyone would like to speak to this application? Would you, Mr. Veit, would like to speak to it? No? Okay, make a motion, we carry this over until next month?
I'll second.
Oh, all in favor?
Aye.
Aye.
Sorry about that.
Thank you. Have a good night.
Thank you, sir.
You too.
I'm so used to not making the motions, I waited for the second. Okay, we do not have a building inspector's report, so we will deliberate on the closed public hearings, which is the SOFR application. Who has thoughts on this before I give mine?
You know what? If you want my opinion,
I do, Kevin.
I don't think white should have been put in that application to begin with. And I didn't, evidently either I didn't read it or there's
What-
nothing in the law that talks
Right.
about colors.
What happened with that was his original application said he was going to put up a stockade fence, and the neighbor thought it was a wooden stockade fence and didn't want a wooden stockade fence, and the neighbor had a white vinyl fence and said, I would prefer to see a white vinyl fence, and somehow it got into the,
Because I think
decision
it-
as part of the conditions.
I think it looks fine. The fence matches the color of his house.
Yeah, it's certainly not an outlandish color. It's a beautiful, it's a beautiful fence.
And I think we should amend the
The original variance,
original
the
variance
variance,
to.
especially
remove that
since he asked. It's not like he put this up.
I agree.
on his own.
That's
And
my
I-
personal feeling. I just think that Mr. Sofer has done everything he's been asked to do. He got the variance, he went to Gary. Gary said you can put up a tan fence. And then somehow.
Tan
it got
inserts,
all blown
right,
Out of
right,
proportion,
yeah.
and now he's got a ticket. So I think we should amend the thing, allow the tan fence, and be done with it. That's my opinion.
Anyone else? Should we take a vote, or we have,
I just want to say, I'm getting really tired of one thing being stated and another thing happening. This is a kind of unique case, but I grow weary of the fences
Well,
all over the place
usually,
here.
though, what happens is they get a building permit for one thing, and then they put up something different. This building
He
permit
did go and
allowed the
ask.
fence.
He did go and ask.
And I think that's a huge difference between what somebody does on their own. He came and asked about it,
No, I said
and it was
is-
approved, you know?
There is circumstances.
Right,
to this
I
that
believe, yeah. Normally, you're right, normally,
I mean, he's done everything he was supposed to do.
right, I mean, he came and
Why
asked,
should he
and,
be penalized?
I have a question for Rob.
Mhm.
Rob, in the event that a approval is given, a variance is given for a resident to put up a vinyl fence of whatever color is stipulated, and then the applicant decides that they'd like to go in another direction and comes back and asks, may I instead install another color? Must that be heard by the board? May it be heard by the board? What's the process?
On any application for a rehearing that has not previously been reheard, the applicant could make a request for modification of the variance, or this board on its own motion could make could rehear the matter.
And it is application by application, it's not precedential. Just because the board decides yea or nay on one, they have the authority to decide differently on another.
As we say, every case stands on its own facts. Here, this board on its own motion decided to rehear the matter based on what was relayed to you by the building department and by the applicant, not yet by application. But based upon that, this board on its own motion voted to rehear the matter for purposes of modification of the variance previously granted, the modification being to change white to tan.
And if future applicants do that, ask, get an approval and come back, they're just taking advantage of they're just utilizing the process.
Not
They are-
necessarily.
That is in the law. They have the right
They have
to
the
come
right to
back.
come back and request that if they want.
One no, and it's done. You need 5 yeses in order to.
Right,
do
this-
it.
I
right.
understand that, but I'm saying
Well,
they
that's our,
they can take, what I'm asking is that the residents can take advantage, or homeowners
Of
can take
course.
advantage
They could
of the
try.
process.
Yeah, the law
They could.
provides for them to come back and seek a rehearing, even on a matter which this board had denied. You do not have to hear it, but by unanimous vote of the board, members present at that meeting, you could vote to rehear the matter.
So based on what you were saying, that the process sounds fair. It doesn't sound anything unfair, unusual, or outside of the law in the process of what he did, of what he's doing.
Correct.
Do we want to take a vote, or are we not ready?
I'm ready to.
I'm just going to say that for future reference, we should avoid stipulations of things
Yeah,
like
that,
colors
Yeah,
unless they are material to the actual application.
yeah.
Okay, can
I think,
comment on that?
There's nothing in the code which talks about color, and we should not get into the business of legislating.
well, the only thing it says is not multicolored, and that's where this was the
Can I comment
problem.
on that? The planning board typically uses its judgment to determine whether colors and architectural review, that's
Right,
what it is.
right.
Right, but I'm saying that arguably, you could say they shouldn't be in the business of deciding color either, but they are.
No, they are,
I
by
don't-
law. They're allowed code.
I don't know that there's anything that would keep us from opining on color.
The
I don't know-
law.
I don't know what,
The law book itself prevents us from picking colors.
ask him that.
He just said that. There's nothing in the law that says that we can dictate colors.
He could-
No, you said the law prohibits us. Is that true?
No, it doesn't
No, no, no.
prohibit us.
No.
But
He's
there's
saying-
nothing in the law that says
That we can?
that we can. There's no color code in there.
Rob, is that accurate?
The only statement is 146.7D, no fence shall be multicolored.
Multicolored.
Now, definition of multicolored.
Right.
So this may be an opportunity to discuss clarification of the code.
Yeah.
Because, for example, this exact same fence exists in Central Valley and was approved, I believe, last year. Same fence, same colors, everything. It is not aesthetically displeasing, right? I think we saw the pictures. Frankly, it's better than, to me, and it's a matter of opinion.
No, but
Right.
I was commenting not on this specific color, but your comment that we should stay out of the color choosing business. That was what I was referring to.
Yeah, in other words,
We should stay
should
out.
say,
I
you have
agree.
to have gray, you have to have red, you have to have, we're not,
Unless it's specifically in the application where someone is saying that they must have a purple fence, then that's
something to
something
decide.
to discuss. But
Right.
in this context, it shouldn't have been there. My 2 cents.
3 cents.
Your 3 cents. So based on that, I'll make a motion that we grant the variance.
For the tan inserts, correct?
For
For the-
sorry, that we modify the existing variance that was granted to remove mention of color.
And allow the tan inserts with the white posts, do we have to
Yes.
say that?
I'll second
I
that.
think it's advisable to state what's there, so that
Okay.
the building department's clear, and so is the applicant, that you're modifying the previous variance to allow a multicolored fence consisting of white posts and tan.
Inserts with the white lattice, okay. I'll second it.
I did it.
I'm sorry. Oh, well, I don't care. Who else did? Okay, put Kevin down. His claim to fame. Okay, we're going to vote. So this is a vote to grant the tan inserts. Joe, how do you vote?
I vote aye.
Gary?
Aye.
Kevin?
Aye.
Craig?
Aye.
And I vote aye. So because it's unanimous, he will get to keep the tan inserts, correct?
Correct. I
Okay.
will prepare a written decision stating modifications as the board has outlined in this vote, present that for signature next month.
All righty, thank you. That's it. Do I have a motion to adjourn? I'll make that motion.
Second?
All in favor?
Aye.
Good night, everyone. Thank you for coming.